The European Union's AI Act has been getting a lot of attention. It's the first major law of its kind, and while most people are focused on how it's going to regulate private companies, there's another side to it that's often overlooked. How does the EU plan to regulate itself? How does a government make sure its own powerful institutions don't misuse AI? Well, that's what we're going to explore. This explainer, by the way, is based on the analysis of Professor Vihar Kiskinov, and we'll be diving into the specific way the EU has built a system for its own internal policing.
So here's our roadmap. First, we'll get to know the EU's main rule for accountability. Then we'll see how that rule was hammered out during the legislative process. After that, we'll break down the formula for how they decide on fines. We'll also look at the impact, which goes way beyond just a financial hit. And finally, we'll wrap up by looking at why this rule is so important for the future of AI.
All right, let's start at the beginning. We need to understand the mechanism the EU put in place to make sure its own major players follow the AI Act. The whole thing hinges on one specific rule designed for exactly this purpose. And that mechanism is Article 100. You can think of it as the AI Act's own internal affairs department. It gives the European Data Protection Supervisor, or EDPS, the EU's independent privacy watchdog, the power to hit the EU's own institutions with some pretty serious fines if they step out of line. And this isn't just a slap on the wrist. It's a real enforcement tool with serious financial consequences.
Now you might be wondering who exactly this applies to. Well, the scope is pretty wide. We're not talking about minor offices here. We're talking about the core institutions of the entire EU, the Commission, the Parliament, the Council, even the highest court and the central bank. It also covers powerful agencies like Europol. This tells you they're serious about enforcing these rules right at the very top.
Here's a really interesting detail: how the fines are calculated. For a private company, the fine is based on its global turnover, its worldwide revenue. But for an EU institution, the fine is linked to its annual budget. This is a deliberate choice. The idea is to have a strong deterrent, but without crippling an institution's ability to do its job and serve the public. It's about correction, not destruction.
The version of Article 100 we see today didn't just appear fully formed. Its journey tells a story of how lawmakers gradually but very significantly ramped up the accountability measures.
You can really see the evolution here. The first proposal back in 2021 had a maximum fine of €500,000. But as the debate went on, the European Parliament pushed for much tougher rules and bigger penalties. And what we got in the final 2024 text is a reflection of that push. They adopted the Parliament's much stricter and more detailed approach.
And the change was pretty dramatic. For the most serious violations, things like using AI for social scoring, which is strictly forbidden, the maximum fine tripled. It went from €500,000 to €1.5 million. That's not just a minor adjustment, it's a powerful signal of the EU's commitment to stop its own bodies from misusing AI.
So how exactly does the EDPS come up with a number for a fine? It's not a random process. The AI Act lays out a very clear and balanced formula with a whole range of factors to make sure the penalty is fair, but also effective.
The EDPS has to weigh a lot of different things. They look at how serious the violation was and how long it went on. They consider how responsible or negligent the institution was. Did they try to fix the damage? Did they cooperate with investigators? The law even encourages honesty by taking into account whether an institution reported the violation itself. A key principle guiding all of this is something called proportionality. It's all about finding the right balance. The fine has to be big enough to be a real deterrent, to make the institution take its duties seriously. But it can't be so huge that it stops that institution from performing its essential public role. The goal is always to correct, not to break.
Another key legal idea here is the duty of care. This means an institution has to be proactive, not just reactive. It has to look ahead, manage risks, make sure its data is reliable, and keep humans in the loop. If an institution fails to do this, it's considered to have a higher degree of responsibility if something goes wrong.
While the fines themselves are definitely significant, getting hit with a violation under Article 100 sets off a chain reaction of consequences that go way beyond just the financial cost. The fine is really just the first domino to fall.
Yeah, you can really think of it as a ripple effect. The first ripple is the financial penalty itself. The next is a massive operational overhaul. The institution will almost certainly have to make big, costly changes to its systems and procedures. But the final ripple, and arguably the most damaging, is the hit to its reputation. A public fine for misusing powerful tech can absolutely shatter public trust. But even with these heavy consequences, the Act has a very important safeguard built right in.
This quote from the law itself brings us back to that core idea of proportionality. The main goal is correction and accountability, but it comes with the explicit rule that the institution must still be able to carry out its essential public duties.
So, let's wrap this up. In a law this big, what's the ultimate significance of this one article? Well, Article 100 is all about a fundamental principle: leading by example.
The core idea is this. For the public to trust AI, they first have to trust the people and institutions governing it. By creating this strong system for its own accountability, the EU is making a clear statement that nobody, not public bodies, not private companies, is above the law when it comes to technology this powerful.
So, in a nutshell, Article 100 has a few crucial jobs. It's there to make sure public bodies set a good example. It creates a level playing field, so the same basic principles apply to everyone. And most importantly, it's there to protect the fundamental rights of citizens from being harmed by AI used by the state. It really is a cornerstone for building public trust in this new digital era. And this all leads us to a big question for the future. Article 100 is a powerful framework for today, but AI is evolving at an incredible speed. So the real challenge for regulators everywhere is this. As our public institutions rely more and more on AI, how do we make sure our rules can keep up with the pace of the technology itself?